everybody. As many of you guys know, I'm a law enforcement trainer and instructor. I train and instruct military and law enforcement all across the nation on various law enforcement disciplines to include constitutional law, case law, patrol tactics, investigation, use of force, etc. And so let me just caveat it with what you see on your screen there. This is not intended to be legal advice. Now, let me also state that I have no idea the further implications of this video. Again, this is just a video clip that was sent to me that I saw, and I get asked a lot as a police trainer and instructor. I get asked a lot, what should I do if somebody unlawfully tries to arrest or detain me, right? That's a question I get all the time from citizens and from other law enforcement. And it's something that law enforcement circles, people in law enforcement circles talk about all the time. So just to start off, I'm not here to give legal advice. I'm not going to give you legal advice. All I can do is tell you what the case law says. All I can do is go through the factual, predicated case law and academic literature that is on this subject and allow you to make your own decisions. So I'm not going to give anybody legal advice. Now, I can tell you what I would do. I can tell you what advice I would give myself because I'm giving myself the advice. So I'm going to tell you what I talk to myself about and what I think. So let's just make sure that we have that fully vetted out. Again, I am not here to give you legal advice. I highly encourage you to find a lawyer that would love to take your money and would love to tell you and give you legal advice on what you should and should not do. So the first thing we have to understand when it comes to making an arrest, when it comes to seizing somebody, right? So if an arrest is going to be made, you need what's called probable cause. So as you can see here on your screen, probable cause exists when at the moment of an arrest or warrant, law enforcement has articulable facts and observations that would lead a prudent, reasonable officer to believe that a crime was in the process of being committed, had been committed, or was about to be committed, more likely than not. And that is flushed out by numerous case law. These are Supreme Court case precedents, and there's even more. So there's so many Supreme Court case precedents, not to mention state and district circuit court case precedences that align with this idea that you need articulable facts and observations. So that is clearly fleshed out in the case law. So you need probable cause. So what if you believe an officer does not have probable cause, right? Well, what do? Are you going to fight back? Are you just going to do everything they say? Again, I can't tell you what to do. I can tell you what I would do in a situation. So giving myself and talking myself through this, if I was ever found to be in this situation, the first thing I'm going to do and the first thing I want to consider is I want to survive the encounter. I think that should be apolitical. I think that should be a bipartisan issue, regardless of what side of the aisle you're on. If I'm having contact with law enforcement as a law enforcement instructor and trainer, I know that every contact a law enforcement officer is going to, he's at least going with a level 1 force because his presence, as we know through the use of force continuum, comes with use of force, right? He is an agent of the state. He or she is an agent of the state. They bring a firearm with them. So everywhere they go, they have the ability to use deadly force, okay? And they are given enumerated powers through their municipality, through their county, through the state, through the federal government to effectuate arrest. Okay, so there are parameters within that, but everywhere they go, a lot of people, what I was taught from the very beginning, right? Policing is, customer service with a gun, right? And so I know that officer, when they make contact with me, has the ability to use lethal deadly force, right? Whether it's justified or not, by them having a gun on their hip, and knives out the wazoo, they have the ability to utilize deadly force. So that's something I'm going to be cognizant of. I want to survive the encounter. So if I believe, or let's say I know for a fact that the officer, for this case, let's just say I know for a fact the officer acts reasonable articulable suspicion as what's needed, for example, for a stop and detain conversation pursuant to in accordance with Texas v. Brown 1979. Let's say I know for a fact, right, that they lack that. Am I going to be competitive with the officer? Again, we're talking about solution-based law enforcement. I'm not going to fight back. Even if I know the contact is 100% unlawful, I am not going to escalate the situation. I'm not going to. Now, I'm going to explain why I would not do it, but I am not going to escalate the situation. Now, does that mean that I have to comply with all their unlawful orders? No, that doesn't mean I have to comply with their unlawful orders, but I'm certainly not going to fight them, and I'm certainly not going to impede them. I just may not help them, right? So when we're talking about what a seizure is, again, let's get Torres v. Madrid, 2021. The Supreme Court holds that the application of physical force to the body of a person with the intent to restrain or seize, even if that person does not submit, is not subdued. So, hey, somebody comes up to me, hey, bro, you are under arrest. I have probable cause, or whatever. You're under arrest. If I know, let's say I know I'm not the guy, right? Let's say for a fact I know I'm not the guy they're looking for. However, I know that I don't have an arrest warrant. I know I am not the guy, right? There's nothing that say hey man, I'm not the guy. Make sure that it's a posture that can't be construed as aggressive. I didn't do anything wrong, right? As soon as they use physical force, boom, I'm in Torres v. Madrid 2021. I have been seized. So if they didn't have reasonable articulable suspicion, already it's unconstitutional. So what I don't understand personally is why people fight, right? You are not going to prove your point roadside, right? A roadside is not where court happens. And I think a lot of this has to do with people are afraid of the booking process. That's the only thing I can think of. They're afraid to go to jail for whatever reason. And I get it. Jail's not a pleasant place. But for me, again, I have a different bias, right? I am a police instructor. I'm a police trainer. I'm a police instructor. So with me, I know that if they didn't have reasonable articulable suspicion, boom, we have an unlawful seizure. So I know the case law. I'm not going to fight them. We need your identification. I'm going to keep my hands exactly where they're at. I may put my hands on my head. I'm going to say I don't consent to unlawful searches of my person. I know that I have been seized pursuant to in accordance with Torres v. Madrid. I also know that this is unlawful because there's no reasonable articulable suspicion pursuant to in accordance with Texas v. Brown 1979. However, I am not going to stop you from unlawfully searching me. My wallet is in my back left pocket, or my wallet is in my back right pocket. Wherever my wallet is, I'm going to tell them where it is, but I'm also going to state that it's unlawful, it's illegal, and I'm going to ask them not to do it, but I'm going to tell them exactly where it's at, because if they want to go in my pocket and grab my, identification, cool, they can unlawfully do it. I am not going to stop them from unlawfully doing it. And yes, if you're going to ask me if I'm going to spit case law to them, I am, because I know that's going to look really good on body camera. It is. It's going to look very good on their camera. It's going to be very good statements. This guy is giving you the answers, and you're still failing to abide by the Constitution. Again, I'm not going to fight. I'm going to tell them where they want to find it. Does that mean I have to give them, all my information? That's up to you. If you want to consensually give it to them, that's fine. But if they have probable cause, or at least in their mind, tell them exactly where it's at. I want to plead the fifth. It's in my pocket. It's in my back wallet. I'm not going to fight you. It's there. It's unlawful seizure. It's unlawful detainment. I've given you the case law for it. You do whatever you want to do. Again, what I am thinking. This is what I am thinking. Another thing to think about, right? So again, let's say that arrest is made. We know this is unlawful arrest. We know that you were not the guy that they're looking for. What happens next, right? Well, again, expect, and again, I know this is going to make a lot of people feel a certain way, expect to go through the booking process. Expect to go through the process, because if they're going to make an unlawful arrest and they're going to violate your constitutional rights, I gain nothing from it from fighting roadside. There's nothing that I get from fighting with them. Even though I know it's unjust, I don't win roadside. I gain nothing. Roadside. There's nothing that says you can't get and win a civil lawsuit or a criminal lawsuit because you didn't fight back. There's nothing that says that at all. So why would I inadvertently put myself in that situation? I'm going to throw my ego. There's no ego. I'm going to throw it aside. They don't need to know that I'm a state investigator or that I'm a task force investigator. They don't need to know that. They don't need to know anything about my pedigree. They don't need to know anything about my my resume. There's nothing for me to say. I'm going to remain silent. Nowhere for me to go, right? Nowhere for me to go in that. So we move on to the next portion here. What happens, right here? What happens if a seizure is found unconstitutional? Well, again, a lot of people may not like this, but this is the Supreme Court case precedents. The Supreme Court held that an officer who conducts a search which violates the Fourth Amendment is entitled to qualified immunity if the officer proves that a reasonable officer could have believed that the search constitutionally complied with the Fourth Amendment. The relevant question that a court would ask is whether a reasonable officer could have believed the warrantless search to be lawful, considering clearly established law and the information which the officer possessed at the time. The Supreme Court also held that subjective beliefs about the search are irrelevant. So again, that's Anderson versus Creighton, 1987. Again, you may not like that, but the officer may be entitled to qualified immunity if they can articulate that a reasonable person would have believed they had probable cause at the time they made that unlawful search, which also would have been a seizure, right? Unlawful seizure. The next thing, let's talk about what happens if an arrest is found unconstitutional, right? So a police officer here in Malley versus Briggs, 1986, a police officer may be civilly sued for monetary damages by the victim of an unlawful arrest. The United States Supreme Court has determined that the question is whether a reasonably well-trained officer in the petitioner's position would have known that his affidavit failed to establish probable cause, and they should have applied for a warrant. If such was the case, the application for the warrant was not objectively reasonable because it created unnecessary danger of an unlawful arrest. Therefore, the officer would not be entitled to qualified immunity. Again, Malley versus Briggs. Now, again, let's go with the case law. The case law is great. Let's continue with this talk about qualified immunity, right? Pearson versus Callahan, 2009. Qualified immunity is a type of legal immunity that protects a government official from lawsuits alleging that the official violated a plaintiff's rights. Only allowing suits where officials violated a clearly established statutory or constitutional right. Qualified immunity balances two important interests: the need to hold public officials accountable when they exercise power irresponsibly, the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. Again, Pearson versus Callahan, 2009. Lastly, this is another one that I think it's important for people to know. Again, my personal opinion, again, my bias, I'm just being honest with you. The United States Supreme Court affirmed that a plaintiff suing for malicious prosecution does not have to affirmatively be exonerated of committing the alleged crime. The Supreme Court's opinion, authored by Justice Brett Kavanaugh, held that no such requirement exists and that a plaintiff suing for malicious prosecution in the context of a Fourth Amendment claim need only show that his prosecution ended without a conviction. The Supreme Court case precedence here is seen as a victory for civil right lawsuits. That's Thompson versus Clark, 2022. So in this case, there's nothing that says that you have to be exonerated of a crime. It just means that, hey, the crime was dropped. So if the DA said, hey, we're just not going to file, well then perfect. That's all you need. And that's straight from Thompson v. Clark, 2022. So again, there's a few case laws here, and there's things to consider. But again, I'm not here again to give you legal advice, but I can tell you what I'm going to do. Regardless of what side of the equation that you're on, whether you're a law enforcement officer that is going to be effecting arrests or you're the citizen that comes in contact with law enforcement, get a lawyer, talk to your lawyer, figure out a game plan with your lawyer. What I'm going to do is I'm going to be cognizant of the case law. I'm going to quote the case law whenever I can, and I'm not going to fight. I'm not going to fight with anybody. I don't need to. Again, if it's found unconstitutional, if it's found illegal, I have a case. Whether it's civil or criminal, I have a case. Fighting gets me nowhere. It gets me no added points and makes me more unsafe. The most important thing, wherever we go, whether we're talking about a police officer, whether we're talking about a neighbor, whether we're talking about road rage incident, whether we're talking about a wild animal, my job in that time is to survive the encounter. And I'm going to survive. And the best chance I have for surviving a encounter is to not be combative, to be 100% willing to understand that, yes, I may be unconstitutionally violated. I may go to jail, even though I've committed no crime. But if I don't fight them, if I don't obstruct them, if I don't impede them, if I let them do their business, my likelihood that I'm going to stay alive is extremely high. It is extremely high. There's no reason to fight. For me, there's no reason to fight. There's no reason to argue. If it's found unconstitutional, great. I have a case, and I will utilize my academic prowess. I will utilize my resources. I will hire that attorney and ensure that justice is served appropriately. So again, that is my opinion on the matter. That is what I tell myself. That is the discussions that I have with myself in regards to this particular issue. If you guys like this content, please like, share, subscribe. Tell me what you think. What are you going to do? Because that's the most important part. It doesn't matter what I think. It doesn't matter what I do. The most important thing is, what are you going to do? Has this video caused you to want to look up more case law? What are you going to do? Very interested to know in the comment section below. Again, please like, share, subscribe, and as always, guys, long live the Republic.